That is very Ogadaesque, which is good. But I think what we intend to do within these very few minutes is to interrogate two things. One, access to justice as we know it, as is provided for under Article 48. Number two, how legal aid then helps in access to justice. And there are a number of issues that are going to emerge. Number one, you know that historically when we talked about legal aid, we simply meant that people who are charged with criminal offenses would be given counsel in murder cases. You also know that we had what were referred to as causes in formal pauperism, when you could file a suit as a pauper. But we now know better. We know that when you talk about legal aid, it cannot be confined to those very narrow areas. That is an issue that is going to emerge. Issue number two that I think Evans is going to talk about is that there is the tendency to look at the law from what I had already said is a very binary perspective. And some of you have already spoken to it. I think Kamala did advert to it. Professor Wabwile also did advert to it. This idea that when we talk, and is by dint of our training, we think about civil and common law. And that is the way we think. And when we talk about justice, we think in that way. And it's Dr. Kamala who said something that perhaps did not catch the attention of many of us when he talked about jury care. When you talk about jury care, it simply means that how you are cared for within these systems about which we are trained. That also is going to emerge. And then the whole idea of formalism, and I think Professor Mbote has spoken to it much earlier than this. When we talked about the restatement of customary law by Eugene Cotran, once you've restated customary law, does it still continue to retain its flavor, or it becomes something else? And the word that she uses to good effect is ossification of customary law, so that it's no longer dynamic. And then the fourth thing that is going to emerge here is how then do we use legal aid in the context of traditional justice systems. And this is the last thing that I want to say before I invite Evans. There is a tendency also to assume that when we talk about customary law, it is uniform. Not true. If you go to Garissa and you are talking to the Somalis about something like murder, which they can settle, how they deal with it is very different from how they deal with this in Tiati constituency amongst the Pokot. And when you go to the Banyala, the same thing. So how do you, in the context of what we are saying, talk about legal aid in a manner that it is germane to this jurisprudence that we are familiar with, and whether there is wisdom in deconstructing our approach so that legal aid becomes something that is meaningful and not a mere appendage of something that soothes and massages our egos, that we are making a contribution. I conclude by saying this, and Professor Mbote will remember, when we were at the university at one time, we offered a course called Customary Law. Nobody took it up. And it was argued that we should abolish customary law. And of course, we then said, how can we, in a Kenyan African setting, say we abolish the teaching of customary law? So on the basis of that, I now want Evans to come and very quickly tease out the issues that we think will be cross-fertilized during our interactions. Evans, may you now mesmerize the audience.
Good afternoon. That's a very hard ask and a very tough act to follow. My name is Evans Ogada. I associate with the University of Nairobi. I'm not going to do kizungu mingi. I'll be short and precise. Our article is quite comprehensive. We will be sharing it with you. Basically, my call to those of us here and my younger brothers seated across is to emancipate ourselves from mental slavery. Robert Nesta Marley. None but ourselves can free our minds. Because if we are to appreciate law as not lending itself to one simple meaning, and the idea of justice as being defined as one way, then we can appreciate the place of African traditional dispute resolution mechanisms. It was Professor Mbote in the morning who told us that the Constitution allows for plural legal systems. Yes, it is true. A read of Article 1, Article 11, Article 44 of the Constitution will reveal that the Constitution tries to awaken that consciousness in us to appreciate that we have plural legal systems. Very quickly, we need to appreciate that traditionally we had viable legal systems in Africa which have dissipated along the way. For example, I know many of us here are familiar with the Magna Carta, 1215, and King John. But none of us, and indeed very few of us, would know that the Monday in 1236 had a constitution, the Kurukan-Fuga. The Somali have a viable jurisprudential system, legal system, undergirded by 6 principles that emphasizes this strict distinction between the faith, which is largely Islam, and the legal system. And indeed, the Somali legal system is a good candidate for teaching of jurisprudence. So those of us who are in the academia, this is a fertile area for us to decolonize scholarship and to bring in our legal studies up to par with our indigenousness. Now, our legal history as Africans delineates the fact that we had procedures, we had principles, we had institutions, we had techniques, just like any other formidable legal system out there. So what has happened along the way, or what happened along the way, especially with the colonial period, was that there was a conscious denial of African law and African justice systems. Now, the control over Africans and the African legal system was a tripod affair. We had the state fighting for control over the law and the justice systems, the state being the colonial master. We have, of course, officials of the local state, the petty chiefs appointed locally, and of course the non-state actors down there. Now, our focus in terms of law is the state. And you will find that in many countries in the Commonwealth, the African legal systems were subjugated by use of what they call the repugnancy clause. The repugnancy clause has trickled and found its way to even the Constitution now. The repugnancy clause was there for a reason. It was a tool for coercion and social control. Having seen the history that quickly, in terms and in the context of legal aid under the Legal Aid Act is a carryover of the statist and positivist inclination or predisposition that we took from the imported legal systems from the British. Now, for us to give meaning to African traditional law and traditional dispute mechanisms, we have to identify some of the features that are in the Legal Aid Act, which are strictly formalist and positivist by nature. So for example, you'll find that under the Legal Aid Act, the court should inform the National Legal Aid Service about the providing for legal aid, identifies an accused person, and informs the service. 2, alternative dispute resolution, which will co-opt African dispute resolution mechanisms has to be provided by an accredited person or institution under the National Legal Aid Act, again, an instrument of formalism. We also have anyone who wishes to benefit from legal aid under the Act has to formally apply. Formalism. Anyone who wants to benefit from legal aid, apart from applying, must also show that there's a prima facie case. We've discussed that before. In our view, these are formalist tools, carryovers from the inherited legal tradition, will be incompatible with the chthonic nature of African law. African law is not written, it's not codified. It thrives on orality. So if you put these formal strictures under the Legal Aid Act, African traditional mores will not be perpetuated. Why should we give a damn about African legal systems? Number one, consciousness. The wave of consciousness is spreading down the globe. We cannot be left behind. We need to appreciate who we are. We are not sub-human beings. We are not subservient cultures. We are not lesser beings or lesser civilizations. African dispute resolution mechanisms have to be accepted as meaningful and constitutive dimensions of the state. Despite the fight and the relentless assault on African dispute resolution mechanisms and African law, our dispute resolution mechanisms have defied the tide and have continued to exist. So we only ought to accept it as a meaningful part of the state because it's now a fringe parallel aspect of our state. We need to accept that. African dispute resolution mechanisms should also be seen as a bona fide cascade of legally dispensed authorizations as an endeavor to give the state its empirical and conceptual unity. We have our small enclaves, the Bukusu, the Luo. We have our legal and political consciousness down there. Why don't we accept these realities, these socio-political realities, and mainstream them within the state? So that I don't go overboard and divert into the realm of Kizungu Mingi, allow me to stop here. The paper will be sent to us. Thank you very much.
Just one point, Professor. Let me just make one point, which simply augments what he said. It is Charles Amala who said something about whose justice. And whose justice is very important because ultimately what is the function of law? The function of law is broadly to create harmony in all its dimensions. And if we agree that that is true, Charles then reminded us the Gacaca in Rwanda. How many people went through the Gacaca system and how effective it was, as opposed to the ICC, which is very familiar with. And I think when we are talking about legal aid, Flora should have been here, we are saying, and of course Professor Wabwile is here, and he talked about children and all these other permutations. We want to say that when you talk about legal aid, it should be seen in a very broad-brushed way. Talk about criminal law, talk about issues like the word I hear us using, cattle rustling. When you go to the Karamojong, there is no equivalent Karamojong word for cattle rustling. It's just restocking. So when there is a conflict, how do you deal with those issues? And I think that we ought to be conscious of those realities so that even when we train acutely aware that these things are there and that the repugnancy clause, inconsistencies with written law are things that we may have at a certain stage to whittle down in order to make legal aid truly useful and functional and acceptable. Let's stop there. Thank you very much.
Gentlemen, I thank you. We will now be hearing from Ms. Jacqueline Ngutia Onyango, and she's joining us virtually.
Okay, good afternoon to you all, and happy International Human Rights Day. It's such a pleasure to be with you all, the likes of Professor Lumumba. I hope I'll be able to mesmerize the crowd with my presentation. So I'm Jacqueline Ngutia. I work with the Kenya National Commission on Human Rights, based at the regional offices in Kisumu. My paper is on integrating human rights-based approach to accessing justice in Kenya. It's in 4 parts. Part 1 focuses on the conceptual framework on access to justice. Part 2 then focuses on human rights and access to justice. Part 3, the legal and policy framework on access to justice. Part 4, the barriers. And lastly, why I wrote the paper is on how we can incorporate human rights-based approach in access to justice. So as listening to speakers from yesterday, we are all in agreement that access to justice is multidimensional concept, and it has to be conceptualized within a particular region. Gone are the days when we should focus access to justice only on legal aid and access to courts, but it is now accepted that issues such as granting equal rights, availability of both formal and informal dispute resolution mechanisms, and ensuring that they are compliant with human rights standard, availability of legal aid, legal awareness, and empowerment to both duty bearers and right holders is important. So access to justice is a process and a goal that must all the time be contextualized. So human rights and access to justice, Professor Ojenda did mention something about this, so I don't have to really deliver on the point, but we know that access to justice in itself is a fundamental right, but also an enabler in respect for other human rights that are protected through strengthening the rule of law. Without access to justice, then other rights cannot be realized. So access to justice is recognized both at the international and regional human rights framework, and as a country we have domesticated. I don't want to mention about the various international human rights treaties that we have ratified as a country, but also looking at the SDG Goal 16, it does recognize legal empowerment as important in development. And when you come to the African region, the Maputo Protocol, the Banjul Charter, we have the Dakar Declaration, so many instruments and documents have been put in place to advance this particular right, the access to justice. And there's a decision by the African Commission in the Egyptian Initiative for Personal Rights, where the commission held that when executive interferes with the court's operation and when a victim is denied access to a counsel, then his rights to access to justice as provided for under the charter were violated. Coming to Kenya, the constitution has domesticated a number of these international human rights instruments from Article 48, 10, 22. Various of these articles do speak about access to justice, and the jurisprudence that you're seeing from the courts, they keep expounding. So access to justice is not just an issue of accessing courts. The recent decision, which I had someone mention yesterday, the Charles Nyaoke case in Kisumu, where the 3-judge bench ruled that murder cases being tried at the High Court is the process is the legal provision is discriminatory because it does prevent an accused person to get more chances of appeal and also justice at the very local level, that is the magistrate's court. So looking at it broadly is that access to justice is a human right, and Kenya as a state is duty bound by the international human rights instruments and the Constitution to ensure that this right is protected, promoted, and fulfilled. We've heard from various speakers on the steps taken by different government agencies in terms of promoting access to justice. The CRJ yesterday focused on what the judiciary has done, the transformation framework and the current one, the sustaining judicial transformation, bail and bond policy, the judiciary ombudsman, NCAJ, which at the local level, where we refer to them as CUCs, all those are very positive efforts. You look at the Office of the Attorney General, the Legal Aid Act, and the enabling regulation, that is a good step in establishing legal aid services to Kenyans. The ODPP has come up with the plea bargaining rules, policy. All these are very positive steps in reducing backlog of cases and enhancing community reconciliation. The National Police Service Act also has very progressive service standing orders. But despite all these beautiful documents that we have, we still have challenges. Many Kenyans lack the legal knowledge on their rights, high costs of accessing courts. If you look at the state of the judiciary report, the 2018-2019 report, backlog of cases is still a huge impediment in realizing access to justice, and majority of these cases are at the magistracy level. So the magistracy level is where most common wananchi can access the court, but you're having a situation where these courts have backlogs. So that means there is a huge gap. If you look at the complaints still in that report, if you look at the complaints that the ombudsman received, majority of those complaints relate to poor service and missing files. There is a UNODC report of 2013, still highlights backlog of cases, prison congestion due to various issues. And you'd find that report also highlighted that the courts prefer imprisonment, even in petty offenses. We have cases of disobedience of court order that is also undermines the rule of law and also deals negatively on human rights. We've heard from speakers today unresponsive justice system for the marginalized persons with disability and women. And this has come out very clear during the COVID pandemic. They're the ones who have been mostly hit and they're not been able to access justice. On corruption, the judiciary, the 2007, I don't know whether this is the more recent corruption survey, but the survey shows that the judiciary is commanded as has the highest confidence on its corruption, but the police is perceived as most corrupt. These are two agencies that must work together on access to justice, but there are different levels when it comes to corruption. That then inhibits the realization of access to justice. So for us as a commission, what we've always been advancing is the inculcation of something called the human rights-based approach, which is a conceptual framework that looks at adopting human rights principles and standards in development in order to protect human rights for all. The foundation is that human rights must be protected, and thereafter you are able then to achieve all other things that you'd want to do. So we have different principles. As KNCHR, we call, we use one that is referred to as PANTHA principle. P, the meaning, it's an acronym of participation, accountability, non-discrimination, transparency, human rights, empowerment, and the rule of law. So those are different principles that must be incorporated in any development or programs that one comes up with. In the context of UNDP, they're the ones who've done quite a lot of work on access to justice. So instead of rule of law and human rights, what they have included, participation, accountability, non-discrimination, transparency, they have included, empowerment is also there, but they've also included linkages and human rights standard. On participation, what human rights-based approach looks out for is that channels, the actors must provide channels for participation for all, especially the disadvantaged. And it has to be meaningful participation. It should not be a situation where you're just ticking the box. That we saw women, we tick the box, women were present, and that is it. It has to be meaningful participation. Accountability, we need to set standards. And how do we then build the capacity of institutions to ensure that they're accountable? If you look at the bail and bond policy, within the judiciary, it's easier that for a long time, the police bond and bail processes has been used to is more of like a corrupt enterprise at the police stations.
Ms.
Non-discrimination,
Jacqueline,
I don't have to say that. Yes.
wind up. Please wind
Yes,
up.
I'm almost yes. So what it does is that it increases the capacity of duty bearers as the state to protect, promote, and fulfill human rights. It also emphasizes on identifying the root causes of barriers to access to justice. So if, for example, the backlog of cases, what is the root cause of the backlog of cases? How can it be addressed? And how do we then bring on board those who have been left behind? If you look at the court-annexed mediation, the report from the judiciary, it has focused more on the monetary aspect of the positive impact of court-annexed mediation. How about relationships? So when the judiciary keeps showing Kenyans about money, this is what the judiciary has brought to fore in terms of the economy, then what does it say about communities who are not looking at the monetary aspects? So as we celebrate International Human Rights Day today, which the theme is Recover Better, Stand Up for Human Rights, the theme is focused on how do we rebuild ourselves after or during the pandemic. But for me, I am saying let's take stock of where we are in matters access to justice. Let's look ahead and view human rights as the only way to ensuring that access to justice is achieved for all. Thank you.
Thank you very much, Ms. Jacqueline. We appreciate your presentation. Mr. Aaron Onyango. Rethinking the National Legal Aid Service.
Thank you. Thank you. Distinguished guests, all protocol observed, I must first begin with an apology. Unlike Professor Wabwile, I have not researched on this topic for 20 years. Therefore, you must contend with my, with my efforts, which I believe were studious. Now, I began by highlighting, or rather giving a background to the development of the National Legal Aid Service and the enactment of the Legal Aid Act, but that has already been said. I will not belabor it. However, I should like to point out that prior to the establishment of the Act, there were proponents who had a pushback, who were against the idea of legal aid, and the justification by dint of Article 24 of the Constitution was that the right was not an absolute right, firstly. So why should we waste all these resources on rights that are not absolute when there are absolute rights that the same resources can be accorded to? They also propose that, the same proponents also argue that there are other economic rights that affect a larger demographic, and as Professor Kameri Mbote had pointed out, the number of people who access the judiciary is quite limited compared to the 50 or so million Kenyans, as opposed to people who access other services such as healthcare, who need access to food and clothing, which are considered more urgent needs. Now I shall proceed to the Act itself. Actually, my points, my bonds of contention were actually sections 4 and 7 of the Act, of the Legal Aid Act, and they effectively give the board and the service its functions. And its functions are basically, firstly, to come up with a system and guidelines for accrediting the paralegals, as has been mentioned. They also are tasked with vetting and accepting or rejecting potential beneficiaries. Once they have identified the beneficiaries, they're also tasked with following the court process with them, or following the type of aid that they are accrued or they are offered. And if, in case during the process, they cease to be indigent, they have to find that out and withdraw the aid offered. And in failure to do so, or if it is found out much later on, they are tasked with the responsibility of regaining or recovering these funds. In addition, the National Legal Aid Service is given legal capacity, which means it can sue and be sued in its own name. What I have just said is the first problem that I wish to explore. There are too many functions accorded to one entity. Too many functions in that it has to accredit, it has to deal with the paralegals, it has to deal with the beneficiaries, it also has to deal with other stakeholders in raising funds. These functions cause numerous problems. Firstly, waste, or rather misappropriation of funds. And I say this to mean that funds are allocated to ancillary roles, roles that are not its core roles. So funds are allocated to ancillary roles, its attention is divided, and it is unable to properly and effectively carry out its core mandate. Another problem that is visible is the duplication of the roles performed by existing parties. We've had some of the stakeholders here who have spoken, constitutional commissions, independent offices, the likes of the DPP, the Ombudsman, all who perform these functions, Council of Legal Education, the Law Society of Kenya. With regards to certification and regulation of legal professionals, we already know that the Council of Legal Education is tasked with assessing and evaluating the competency of lawyers and paralegals. It shares these functions with the Kenya School of Law, which assesses them, and the Law Society of Kenya also regulates lawyers by certifying or rather renewing licensing practicing advocates annually. With regards to accreditation, this is a function performed by both governmental and non-governmental bodies. Indeed, in the proposed mediation bill, there's a proposed mediation accreditation committee that is to be tasked with accreditation of mediators. With regards to arbitration, the National Center of International Arbitration, under its own act, has been mandated with the accreditation of arbitrators, as well as all the independent organizations that are approved by NITA to accredit these organizations. So why do we give a service that is already strapped with money this function that is already performed by all these other organizations? In addition, we have non-governmental organizations such as FIDA and Kituo cha Sheria, which also have their own reputable regimes of accrediting lawyers or the legal practitioners who they work with. And with this regard, I conclude that the duplication of the roles has led to so much confusion also regarding where parties should go to when they need legal assistance. One of the speakers in the previous session stated that some organization, I think it was FIDA, there's this conception, I don't know if it's a stereotype, that it serves ladies more than men, or it is more swayed in that direction. Therefore, if I am a lady with an issue, will I go to FIDA? Do I go to the DPP? Do I go to Kituo cha Sheria? Or do I go to the National Legal Aid Service? This is one instance where more is not merrier. These implications have negative impacts. These factors that I've mentioned have negative impacts. I shall only highlight two, which is the cost implications. Firstly, in the regard that the numerous functions each require money and resources. And I've never actually, frankly, had a government agency or any government in Kenya saying it has enough money. They all are always short of money. And in addition, they require the workforce to perform these numerous tasks. This means that there are more people to pay, and when they retire, the retirement benefits add pressure on the wage bill. Another negative impact is divided attention, and because of the numerous functions that it has, trying to figure out how to come about with a system of accreditation, dealing with stakeholders, and its core function, raising funds, its attention is divided, and like I said before, this prevents it from fully focusing its attention on its main aim, which was giving effect to Articles 48 and 50 of the Constitution, which is the right to fair hearing, I believe. Now, I not only have the negative effects, but I also offer remedies. I propose remedies, and the remedy is the reduction of the functions of the National Legal Aid Service, and it can be done in two regards. The first way is to strip it of all its functions except quality assurance, which is basically regulation. Quality assurance will basically mean that it will work with all the already existing stakeholders in the field of legal aid to ensure that they all meet their required and accepted standards of legal aid. This model has been applied in other sectors, such as the communication sector, with the Communications Commission of Kenya, that only deals with the regulation. It does not involve itself with the provision of the services of a telecom service, radio service, or broadcasting. That is done by another state organization, which is KBC. The other solution that I offer, which is my preferred solution, is all its functions should be stripped, save for operating as a fund. The main agenda, of funds, or availing of funds for legal aid. And then this should remain its main focus if, as I've already demonstrated, the other functions are already performed. It's not doing anything new except giving funds or availing funds that were not previously present. So this should remain its main focus. However, if this route is to be followed, I offer two words of precautions. The regard that, following the reality, the prevalent reality of our country and the problem of corruption that we are grappling with, the proposed funds, avenues of raising money should be limited to government allocations, grants, and donations. All of its investments should be restricted to low-risk government-initiated investments, such as treasury bills. And the only monetary transactions it should be allowed to have with individuals and private parties should be limited or administrative functions for administrative purposes. This should be done because the likes of the National Social Security Fund have been in the news, and NHIF have been in the news almost monthly, implicated in corruption, scandals or matters of graft, where public funds were misappropriated through terrible investments that are meant to be white elephants, where corrupt individuals could benefit from public funds. The Hazina Towers case is one such scenario where 7 billion shillings was lost by taxpayers in a quest for a fund to acquire a building that is almost empty. There is no point in having a legal aid service that has more watchmen than some security guard companies, which at one point it was reported by the media outlets the Social Security Fund had, because it had so many properties that required guards and nothing to do with them. In conclusion, I therefore state that it has been demonstrated that the fund, that the act, and by extension, the service, suffer from inefficiencies, and these inefficiencies are brought out by the numerous functions that have been placed upon it. And it would be practical to strip the functions that are already performed, and that the same functions and services be attained in cooperation with the existing agencies, the stakeholders, government offices, constitutional commissions, and that the service focus on a single purpose, which can be regulation or that of a fund. And failing to do so and expecting different results than the same inefficiencies that it experiences now would be tantamount to, as what my professor of jurisprudence, Gidhu Muigai, often likes to comment, would be nonsense upon stilts. Therefore, with those few words, I take my leave. Thank you.
Mr. Onyango, your paper is something I'd like to read. It is as disruptive as they come. That was wonderful, wasn't it? To hear it from him. That would be an interesting read for me. I'm sure the NLAS would like to read. I would actually want to look at it before the end of the day. Mr. Wambua, my friend, will speak to us on the role of county governments in promotion of access to justice to poor and the vulnerable. He will be prospecting for concurrence of functions under the Constitution of Kenya.
Yes, good afternoon. Okay. Probably I don't need to introduce myself again. Oh, what's happening? Next slide here. Oh, we can use that. Okay, so do you recognize any person there? Any familiar face? Yes, that's me, in one of my best African shirts at that time. And here we were with the Deputy Governor, Mombasa County, Chief Magistrates, Mombasa Law Courts, that's Honorable Makori, the Executive Director of Huria, that's a coast-based NGO, EU representative there. So we were opening the Mombasa County Legal Aid Unit. So it's a unit that was set up as a joint partnership between Huria, the NGO, and the County Attorney's Office of Mombasa, County Government of Mombasa. So before Dan, you joined me this day. On this day, I enjoyed my 5 minutes of fame. I was invited as the only UNDP representative there to officiate the opening ceremony. So later that evening in my room, I started asking myself, does the county government have a legal mandate in establishing a legal aid scheme? Did I partake in an illegality? Will I lose my job as a result? So I set off on a rather long legal inquiry, which hopefully will terminate today if my paper is accepted by Egerton University. And I was asking myself, so what is the legal basis of county governments establishing legal aid schemes? Because if you read, if you look at the Legal Aid Act, and the Legal Aid and Awareness Policy of 2015. We also look at the fourth schedule to the Constitution, the division of functions listed in that schedule. We can easily come to a conclusion that provision of legal aid is indeed a national government function. So the question we're asking ourselves, so what is the legal, under what legal basis did the county government engage in that initiative? And if the county government at all has a mandate, then we can only establish that mandate by looking as to whether there is concurrency of functions and powers. Of county governments. So in this paper, I first looked at the conceptual link between legal aid, human rights, and governance as a way of trying to establish a theoretical basis for concurrency. This is what I found, that there are three conceptual bases for justifying provision of legal aid as a right and as an obligation. Right for citizens and obligation for government. And the first justification is that legal aid is important in advancing the right to access to justice. And I think many speakers in the morning gave justice to that particular discourse. Prominent of them was Professor Ojienda. Only that I needed to add, there is also a justification stemming from the international legal frameworks, particularly the International Covenant on Civil and Political Rights. Legal aid is indeed a right, particularly for those who are facing serious offenses in municipal tribunals. I think that was first articulated in the case of Jamaica. It was, forget the name. I forgot the name, but it was a Jamaican case that was litigated at the United Nations Human Rights Committee. And since then, we've also had the same decision affirmed in our own African Commission on Human Rights, Human and People's Rights, a Burundian case, which you'll find in my paper. So besides the human rights justification for legal aid, there's also a welfare justification, and this is based on utilitarian theories that ascribe a fundamental rationale in providing legal aid, in the sense that legal aid provides benefits, welfare benefits, particularly to the poor. And on that basis, legal aid is seen as a fundamental obligation of government, because government is supposed to guarantee the welfare of its citizens, particularly those who are disadvantaged and the poor. And in calculating welfare benefits of legal aid, cost-benefit analysis have been done. Like, for instance, in the UK, it was found that for every single dollar invested in legal aid schemes, it accrues $2.4 in terms of welfare benefits. And these welfare benefits could be the savings made in decongesting prisons, the limited time, the time savings that are made in court proceedings, because that money can be redirected to other useful welfare programs like education for the poor and things like that. There's a third justification, which is on sound governance, and that legal aid is meant to promote inclusion. If you give the poor the right to challenge government decisions by affording them resources to pursue public interest litigation, you're also giving them an opportunity to participate in the governance of the affairs of their country. And therefore, that provides a third theoretical justification for legal aid. So how does this, therefore, pan out in Kenya in trying to establish concurrency of function and the mandate of legal aid? And there are about 4 entry points that I would like to point out, based again on those theories that I've talked about. One is that the binding nature of the Bill of Rights, and you can also add Article 10, the national values and principles of governance. The binding nature of a Bill of Rights on the state and state organs will therefore create a basis for county governments to say that we also have an obligation as state organs, because that's how they've been defined and also elaborated in this Andrew Jeru case, that we also have an obligation, therefore, to avail the right to legal aid to citizens within our respective jurisdictions in the 47 counties. And the second entry point is the fact that the Bill of Rights under Article 21 also obligates the state to develop and adopt legislative, policy, and other measures to guarantee Article 43 rights. Now, for Article 43 rights outline the various socioeconomic rights which citizens are entitled to. Now, these socioeconomic rights are also correlated to the constitutional functions of county governments. The right to food, the mandate of county governments on agriculture. Yeah? The right to health, attaining higher standards of health. The right to, that relates to the county function on health. Right? And we can talk about all of those Article 43 rights, and you will see that they can be pigeonholed in all of those functions of the counties. So therefore, if counties have a mandate, therefore, to provide for these rights, international standards on realization of socioeconomic rights also require the state to provide for measures for judicial access, monitoring, and accountability. So what that means is that the county governments, as part of the state, therefore, have a mandate to ensure citizens have access to judicial remedies whenever their Article 43 rights are violated. So that creates an entry point for county governments to say, yeah, we also have an obligation to put in place legislative measures to ensure citizens access these rights. The other point is that there is a duty imposed on the state to address needs of vulnerable groups. Again, it has been mentioned here in the morning that legal aid is also one of those social policy tools for addressing the needs of vulnerable people in our society. The other entry point is on looking at the objects of devolution, and in particular, the one that talks about facilitation of decentralization of state organs. Now, the judiciary is one of the state organs that has embarked on a program of decentralizing its services to each and every county. In other words, the judiciary has committed to have a high court station in every county. The judiciary has also committed itself to have a magistrate court in every sub-county. And the county governments have facilitated that by providing, for instance, land and premises to the judiciary to facilitate the decentralization. So in a situation where the National Legal Aid Service has delayed its decentralization, from a utilitarian point of view, shouldn't county governments, therefore, set up legal aid units or legal aid schemes as a way of ensuring that citizens, particularly the poor, enjoy these benefits in the absence of a decentralized, properly decentralized National Legal Aid Service. Then lastly, the Constitution also imposes on the counties an obligation to facilitate self-governance and participation of citizens. Now, legal aid is one social tool, one of the many social tools for facilitating inclusion, and therefore ensuring citizens participate in governance at their local level. So doesn't this obligation, therefore, create a basis for counties to say that, yeah, we also have a mandate to facilitate legal aid at the local level? So those are the entry points. So now back to my 5 minutes of glory in Mombasa. How did this county legal aid service come up? There is a justice gap in Mombasa, if you look at those statistics there. So Huria, the NGO that we support under Plead, came together with the county government of Mombasa through the county attorney's office and established the legal aid unit. Now, by September 2020, despite COVID disruptions, the legal aid unit or center had already attended to 436 cases. So that shows that in reality, that unit was functional. It was working, right? So its viability is not in doubt. What is in doubt is its legal viability. So, but then there are issues that have arisen in the establishment of that particular unit. One is that the county government based its legal mandate in establishing the unit on the provisions of the Mombasa County Attorneys Act of 2017. Now, in that act, I think among the functions and powers of the county attorney is to establish a legal aid service unit. It also empowers the county attorney to institute cases and litigate in public interest. Therefore, the county attorney can initiate public interest litigation. Now, when the National Parliament enacted the Office of County Attorneys Act in 2010, this year, looking at the functions of the county attorney, there's nothing on establishment of legal aid units. There's nothing on pursuing public interest litigation. Those functions are absent. So the question is there a conflict between the national law on county attorneys and the county law, for instance, the Mombasa County law? And by the way, about 10 other counties have established, they have enacted their own county attorney's office laws. So is there a conflict of interest? So thankfully, Article 191 provides for a basis of resolving conflict of laws, that's between national and county laws. And in the principles that have been developed, one of them is the uniformity principle, that yes, the national government can enact a national law for purposes of ensuring uniformity of standards. And looking at this national law on county attorneys, one can say probably it's a framework law that has been established to ensure that counties don't come up with funny laws that establish the office of the county attorney. So the question is, can we interpret this law in a way that takes away the functions of the Mombasa county attorney in establishing the legal aid? There is case law to say that when interpreting this conflict of law situation, do not preempt functions of counties that are reasonably invested in counties by the Constitution. Now, in my earlier submission, I'd already said that if you look at the Bill of Rights, if you look at the objects of devolution, probably, not even probably, indeed, there is a basis of saying counties have a mandate to facilitate provision of legal aid within their jurisdictions. And therefore, in this conflict, the provisions of the Mombasa County law would prevail. Secondly, the second issue relates to regulation of county legal aid centers. So who regulates these county legal aid centers? Won't we find ourselves in a race to the bottom, lowering of human rights standards by counties in order to gain one strategic advantage of another county? So the provisions of the Legal Aid Act 2016 probably would be useful. Legal aid service providers are supposed to be accredited by the National Legal Aid Service. Now, among the listed categories of legal aid service providers are state agencies. So in this case, I would imagine, or rather I would submit that the County Legal Aid Center can be viewed as a state agency that therefore could be accredited to provide legal aid, and therefore benefit from resources from the National Legal Aid Service. But there's a conundrum here. The accreditation legal framework is not complete. Paralegals are supposed to be accredited after having gone through a training program which has been accredited by the Council of Legal Education. Now, the Council of Legal Education has not developed that framework. So if the County Legal Aid Center is to employ paralegals, for it to get accredited, then those paralegals have to be accredited. But then the Council of Legal Education has not provided for a framework for accrediting paralegals. So this leaves the legal aid centers in a sort of conundrum, unless they seek accreditation on the basis of having employed advocates. There's the question of independence of legal aid centers. And hypothetical question is, what if an indigent went to this center seeking legal aid to sue the governor? The county attorney is now a member of county executive answerable to the governor. He or she is in charge of the center. So is it possible really, practically, for that to happen? Yet, the Lilongwe Declaration on Legal Aid requires that we establish legal aid centers or units that are independent from the Ministry of Justice of the respective governments. So this is a challenge, of course, unless we create a legal framework for these centers that secures the independence from the office of the county attorney. The other question is issues of funding for these centers. Despite this center being set up, I looked at the Mombasa annual development plan, which forms the basis for budgeting. There was no allocation for this center. Yet, the county government allocated 25 million for construction of our county courts. Now, when I look at the structure of our courts, there's nothing like a county court. Just subordinate courts, High Court, Court of Appeal, Supreme Court. So what is a county court? And is in construction of courts a mandate of the national government? So isn't that an instance of policy coherence? Shouldn't the 25 million shillings be better invested in these structures rather than in a function which is reserved for the national government? Then lastly, there's weak linkage between this center and the alternative justice institution. And I think this is something that has been discussed here. Where this center is situated within the precincts of the Mombasa Law Courts. Now, the MOU that establishes the partnership between Huria and the Mombasa County government does not talk about legal aid for the alternative justice systems or cases in those systems. So there's a weak linkage between these. So what are the prospects? I'm just about to finish, Mary. What are the prospects? One, there's goodwill. There's an enormous amount of goodwill for provision of legal aid, state-funded legal aid in this country. The government has prioritized legal aid as a flagship under Vision 2030 MTP3. Development partners have also demonstrated goodwill, and that's why we have plead, and that's why we are here. Civil society is also well ready and willing to partner with county governments. Besides Mombasa, we also have a partnership of this kind coming up in Wajir. Now, so maybe county governments and civil society organizations should exploit this goodwill. Secondly, there's an oversupply of lawyers. So any county that wishes to establish such a center, you will never lack personnel. Mugure here tells me there are about 7,000 trained lawyers who've not been admitted to the bar, who are just floating somewhere in this republic. Now, those people are crying for employment. And in one of the cost-benefit analysis that was done for establishment of the legal aid system in Uganda was that it would bring employment benefits to paralegals. So there is a benefit that is yet to be tapped there. The third prospect is, of course, leveraging on intergovernmental relations mechanism. County governments can lobby for the formal recognition of their role in this particular area, and it is notable to read that the county attorneys have already established their forum, and they are now busy lobbying the government at both levels to recognize and facilitate their work a little bit better. Lastly is that we now have an AJS policy which can provide policy basis and therefore normative linkage between the legal aid units established by the counties and the alternative or informal justice systems within the counties. So I conclude to say that, yeah, concurrency of functions does exist between the two levels of government. And I also say that the emerging practice of counties establishing legal aid centers should be nurtured through legislative development, through jurisprudence, through policy support, and lastly, through intergovernmental coordination. Thank you.
When Mr. Ambu asked the first question, whether county governments have a responsibility to provide legal aid, my answer was no. I will have to read his paper with a lot of humility. I promise you that in the next 20 minutes or so, we shall be done with our presentations and go to plenary. Miss Dr. Annette Mbogo, is she near? Yes. We will hear her as I try and see if Dr. Kenyan is virtually with us.
Good afternoon, everyone. I'm told I have 10 minutes, so I'll be very quick. So in the program, my article is indicates that the title is State Capture of Paralegalism. But when I was writing the full paper, I kind of changed the title of the article. So my article is now entitled Pouring New Wines in Old Wineskins, State Capture, Contestations, and Conflicting Interests of the Paralegal Approach in Kenya in the Advent of the Legal Aid Act. I'm guided by a biblical statement on pouring new wines in old wineskins. And the reason I use that analogy is looking at first the role that community paralegals have played in promoting access to justice for indigent communities in Kenya. So the paper first starts at looking at the role that community paralegals have done and looking at it historically, where civil society organizations such as Kituo cha Sheria, where I work, integrated the paralegal approach in programming on access to justice. And it is through this kind of work that community paralegals were very key in promoting social change within their communities. So the paper first looks at the importance and place of paralegals, but then looks historically at the challenges that paralegals faced in terms of recognition and acknowledgement. And looking at the time when the paralegal approach was used in access to justice work, we trace it back all the way to the 1970s, when such civil society organizations began working with paralegals. And it is only until 2016 when there was actual formalization and acknowledgement of the role that paralegals play. So we are talking of around almost 50 years where this particular group of people have been working but not receiving recognition from the government. So when the 2016 Act was enacted, there were several gains in terms of paralegal recognition. And one particular gain is just the fact that paralegals were defined in the Act, and they were recognized as legal aid providers. And many civil society groups really took this as a very progressive step in terms of looking at the role that paralegals would play in legal empowerment projects. But the formalization, which obviously involves the state, has come with a number of clawbacks, and the clawbacks is what my paper looks into. The first clawback looks at just how the paralegal is defined in the Act. And if you look at Section 2, a paralegal is defined therein as a person who has undergone training that is approved through a curriculum that is approved by the CLE. So that, in essence, means that looking at the paralegals who have served and even currently are serving, that they will not fall as paralegals or recognized as paralegals under the Act. The other issue relates to paralegals being listed as legal aid providers, but then requiring that paralegals must, for them to then provide legal aid, that they must be within or members of a paralegal society. So we all know how registration of societies may be very difficult, especially when you look at, historically, what kind of people have we had who have served as paralegals. And that means that indeed that they need to be organized within a structure or a registered society and be members of that society for them to then provide legal aid services. And this can prove very problematic in the sense that at the moment, I think when you look at the discourse within the sector, is that the Paralegal Society of Kenya would be the umbrella body within which paralegals would require to be members. But the Paralegal Society of Kenya, which is more of a national body, may not have the capacity really to recruit as members all nationwide paralegals. And so this may really pose a challenge in terms of what kind of people would then be able to provide legal aid services as paralegals. In addition to that, in addition to that is that as we speak right now within the sector, paralegals are organized as within networks within their regions. And so requiring them to then be mobilized within a national body would then problematize the networks that they already have within their own regions. And I think the Act would have borrowed from the structure of the LSK, for instance, where we do have a national legal law society of Kenya, but then we have branches as well. So branches then feed into the National Law Society of Kenya. And it's important then to work within the regions, because those are people who you're closer to and who understand the issues that affect your particular group. The other issue relates to how the Act itself views paralegals and the training program. As we speak right now, a number of civil society organizations are training individuals as paralegals. And the trainings will vary a lot, as the CEO of NLAS said. So some organizations may train paralegals for a period of 5 days or 2 weeks, but then it is a continuous training throughout the work that they are providing. And in as much as the current curriculum has not been developed, the challenge with having a formalized training is that many paralegals, as we know them, may not be able, one, to take time, for instance, to undergo a training of that nature, and also may not have funds to be able to support their training of that kind. And so then this would mean that we lock out a number of people from being paralegals. So my argument is that there is a need that the Act should have reflected on what is already on the ground. Because then when you have a new set of legal provisions that you then wish to apply within a context that is already operating, and you have these systems already entrenched and operating, then the uptake of the new rules may not really be taken up by the communities or the stakeholders that are involved. And so in doing so, would have the law being ineffective in terms of achieving the mandate. So my proposal in terms of how do we move forward from there, because I'm not saying that then we should amend the Legal Aid Act, because it has taken so much to just have recognition for paralegals under the law. But what I am proposing in the paper is the importance of stakeholder coordination and discussion around issues relating to paralegals and how we will implement those provisions under the Legal Aid Act, in a sense that we can separate paralegals who are paralegals as professionals and community paralegals as we have known them, who act more as agents of social change within their communities. And I think that distinction ought to be made, that we can have people who are professionally trained to play that role of a paralegal, but then at the same time, we need to also recognize the importance of, just community members who may not have very, lengthy formalized training, but who, with the basic legal knowledge that they have, can be agents of social change and can contribute towards access to justice within their communities. So my argument is that the law is then now seeking to disrupt the existing structures and the existing paralegal movement, and by doing so without proper coordination and proper participation of the paralegal movement, then we will reach a point where we'll diminish the efficacy of the movement and, in a sense, slowly cause the movement to die. And I think one last point relates to the Legal Aid Fund. And one of the main problems that paralegals have faced through the years is the lack of financing. And the Legal Aid Fund provides a very good opportunity for paralegals to access those funds, in which they can undertake their work. But the financing under the Legal Aid Fund has a number of preconditions that they have to fulfill before they access the funds. And I think one precondition, as I mentioned earlier, is that relates to being a member of a society that works with paralegals, and also having undergone the approved training by CLE. And as we speak again, as I said earlier, that those pose a number of challenges, even in terms of just looking at what kind of people, especially those who have been serving already, will be able to really fulfill those requirements. So in a nutshell, going back to the title, my argument is just that the new framework, well, not really new because now it's 2020 and it was established in 2016, is like, takes the perspective of as if it's being applied within a vacuum where there were no existing structures, which is really as if you're pouring new wines in old wineskins. So that is all I'd like to say. Thank you very much.
Ladies and gentlemen, I know you're tired. I am not tired. I was waiting for you to ask, and no one is asking. So let me volunteer the information. We will hear the last presentation for the afternoon, which will be done on behalf of Dr. Ruth Aura on enhancing access to justice through law school, legal aid clinics, the dual role. Are you ready? I think so. Where is that energizer? You remember that advert? The batteries keep going on and on and on and on. Are you ready? You are? Yes, so this gentleman will take exactly 10 minutes, and then we shall have a discussion for another 10, and then tea.
All right. It is my hope that I'll take less than 10 minutes. The title of the paper which I'm discussing on behalf of Dr. Ruth Aura is Enhancing Access to Justice Through Law School Legal Aid Clinics. The dual case, the dual role rather. What this paper is discussing, it's actually looking at the double role that is played by law school legal aid clinics in creating an environment for greater access to justice for those who are marginalized and those who are in need of legal aid and assistance. It's pretty much sort of the story of the Faculty of Law Legal Aid project, which is one of the co-hosts for this event. So using the framework that was given to us by Professor Kameri Mbote, when she said that one of the best ways to analyze systems is that we need to look at the norms, we need to look at the actors, we need to look at the structures, and then we need to look at the systems. So we will begin with the norms. By now, all of us have heard time and time again the provisions under the Constitution, the provisions under the Children Act 2001, the provisions under the Persons with Disabilities Act, and the provisions under the Criminal Procedure Code. So I will not rehash those arguments. So generally, those are the norms which underpin legal aid provision, the legal aid provision regime in Kenya. Now, the other principles, apart from the norms, there are the general principles, the principles of inclusivity, non-discrimination, the principles of social justice, accountability. Those are the general principles which animate the norms so that they give them operational effect. Now, turning to the actors in the case at hand, as I've said, it's discussing the contributions of the Faculty of Law Legal Aid project at Egerton University in enhancing access to justice. And the dual role is, number one, that it provides a means for persons with unmet legal needs. These are people who are marginalized, people who are impoverished, people who have limited knowledge of the law, people who find it difficult to access formal justice systems, and other people who may not really trust the informal justice system. So those are the target group that the Egerton University's Faculty of Law Legal Aid project has been dealing with. The second contribution is that it affords students with an opportunity to get to learn the practical aspects of the law. So in the process of the legal education that is being provided at Egerton University, the students also participate actively in the process of engaging with these individuals who the Faculty of Law Legal Aid Project is reaching out to. So I will focus on what are the key benefits of the Faculty of Law Legal Aid Project for the persons in need of legal assistance, as well as for the students themselves. So for persons in need of legal aid and assistance, it creates an environment of greater awareness of their rights and greater knowledge of the law. So many individuals who engaged with the Faculty of Law Legal Aid Project, when they were during the first encounters, many of them expressed surprise that there is actually a legal framework that protects their rights. Others were not aware that there was a process in which they could gain, they could obtain redress, they could protect their rights, they could exercise certain liberties and certain guarantees. And more importantly, it provided a basis for the extension of legal advice, assistance, and so on and so forth, without the need to pay. So it provides the opportunity to gain legal services without the obligation to pay afterward. Now, turning to the benefits of legal aid clinics to students, is that it improves their interviewing skills a great deal. It also sharpens their writing and research skills. In addition, the students get an opportunity to actually learn about the principles of professionalism in their engagements with the clients of the legal aid project. As Professor Wabwile said yesterday, that in some of the engagements in different areas where the clients provide their stories, and you could see the students actually relating to the problems which these people are facing. They were empathizing with the difficulties that were confronting these individuals. And to confirm what he said is that the students actually cried with some of the clients. So this creates a social justice and accountability awareness in them. They see that there is a means by which the law can actually make a change in the life of some of these individuals with unmet legal needs. Now, turning to a comparison of the legal aid program at Egerton University in comparison with other jurisdictions, particularly South Africa, Australia, and the United States. The difference between the Faculty of Law Legal Aid project and similarly placed programs in these different jurisdictions is that we find in these other jurisdictions there is already in place a state-funded program. For example, in Australia, there is a state-funded program which expands across the different regions, and whereby university students, before clearing their undergraduate degrees, there is a mandatory time period in which they need to engage in community service. That obligation does not exist under the Kenyan system. Although we have the obligation for students before being admitted to the bar that they have to undertake pupillage, that is not the same as undertaking legal aid and assistance work, because in our case they are working either at a law firm, either at the judiciary or other accredited institutions. So the main argument in the paper by Dr. Aura is that in these other jurisdictions, there is already in place a framework in which there is an embedded nature of legal aid clinics at law schools. There are provisions in place. For example, in the United States, there are legal aid clinics in diverse institutions. So for example, at Georgetown University in the United States, they have already in place a thematic legal aid clinic that engages in specified areas of the law. And these clinics are actually licensed to offer legal services so that the students actually undertake legal advice and engagements with the clients under the supervision of an advocate. Under the Kenyan regime, such regulations are not yet in place. And even if there is a broad framework for that possibility, they are not yet operational. So those are some of the things that going forward, these are aspects that need to be taken into account. If indeed legal services are to be extended to the doorstep of those most in need, there is a case to be made that in order for it to be sustainable, there have to be specific regulations in place which enable the larger population of students to actually participate so that in future when they qualify, they will continue. So that's the aspect of sustainability, that it becomes self-regenerating. Now, this is the second last point. What are the challenges that have been faced by the Faculty of Law Legal Aid program and other institutions offering legal aid? There's always the aspect of financial resources. It's resource intensive, and sometimes finances may be limiting. Also, there may be a lack of awareness within the broader communities, particularly if a legal aid clinic is operating within a restricted boundary zone. So those who are outside the area of coverage may not be aware of such possibilities. Then there is the serious lack of a university legal aid association. That's something that needs to be looked at. Now the parting shot of this, this is the concluding point of this presentation, is that legal aid in Kenya is a game changer for the indigent, and it is a means for transforming lives, so that there is actually an important clarion call to be made, not only to university legal aid clinics, but also to practitioners, also to people in the civil service, that let us support legal aid at the university law clinics. Thank you very much.
Ladies and gentlemen, when we started this afternoon, my student, Ms. Kenyan, needed some time, and she has had plenty of time. She was supposed to be the first presenter for the afternoon, and she says she needs 5 minutes. But as we allow her the 5 minutes, I urge you to please reduce your comments into writing if you haven't done so that in the event we are unable to take all the questions, we will submit them here, and the authors and presenters of the various papers can be able to maybe address them in their responses. So allow me to welcome my student, Ms. Kenyan, to make her 5 minutes presentation.
My name is Nyokabi Kenyan Ngare. I'm the founder of African Woman Global Initiative, and I'm here to present to you, if you look at the topic that I'm presenting, it's on improving access to justice through technology. It's a case study of the Kenyan legal system. So I'll be very brief. I'll not go through the whole paper. So as we all know, the Kenyan judicial system has had to undergo a major transformation following the COVID-19. So there has been need for technology that provides information, technology that connects individuals to attorneys, and technology that automates and produces documents. So I'll briefly go through the challenges and the benefits, and then I'll conclude. So the challenges that we've had that have come with this transformation is that, one, the platforms that are being used currently in courts are not user-friendly. We find that the court needs to come up with user-friendly and stable platforms that to hear the cases. We also find that them implementing electronic case management was meant to be successful, but we find that there are so many challenges with the filing, and there are so many challenges with the filing system, and there are issues with fee payments and also filing of bulk documents. The other challenge that we are facing is virtual court challenges, where we find that we need a more secure platform due to impersonation of advocates and witnesses, digital signatures. Persons with disability have no one to assist them. We also have language barriers, where we find that there are no translators, and there are no resources. So this results to low-income families and individuals can't afford to get the help that they need. The other challenge that we have is that when it comes to communication, we find that the judiciary email address does not work. So we are forced to send our, we are forced to use the Gmail accounts. And the question is this really safe is this really safe to use? Some of the benefits that we've come across is that the cost of litigation and logistics has reduced. And then we find that there's faster disposition of cases, and there's improved judicial record management. In conclusion, I would say that the introduction of ICT into the electoral process and administration of justice has actually increased transparency and efficiency. Thank you very much.
Isn't she wonderful? So, ladies and gentlemen, I shall now open the floor. I will ask our able gentleman with the microphone to move it around for comments, questions. I was just writing Mr. Aaron a note to say he needs to look at the advocate's bill. The last time I saw it, it was dated 2015. I don't know if there is another version, because that bill can allow you to make the sort of recommendations that you're making. Regulation of practice of law in Kenya today is the mandate of the Law Society of Kenya, and you might find a home in that bill for some of the recommendations that you're making, which I like. So there's a microphone right there. We will take comments and questions.
Aaron, I just want to confirm that I heard you correctly. When you said that in your view, the Legal Aid Act should only confine itself to funding, and that all other functions are being dealt with by other organizations. I would want to hear just 1 minute clarification, because you are going to render quite a number of people jobless. That is the immediate thing, but I would want to hear the wisdom of that a little more, if you don't mind.
In our hurry to conform to the strict timelines, I forgot to make mention of the alternative justice systems policy by the judiciary. This is the document for the future for us as a legal community, as a legal system. So whatever we think, whatever we proselytize in terms of legal aid, it has to bear in mind of the beneficence that the alternative justice systems policy under the able hands of Justice Professor Ngugi have articulated therein. So my argument will be, let's think of AJS as involving much more than the lawyers and lawyering, and let us deworm ourselves from positivist and statist orientation of law. Law is much more than what was deposited and sedimented by the departed colonialists.
A quick question addressed to CLE. In Dr. Gakeri's presentation yesterday, it was mention was made of the fact that CLE requires universities to have a law clinic, and it demands this of them. So I was curious to know whether this demand is drawn in legislation, is it in certain rules or guidelines? Thank you.
Thank you. My greatest take home is going to be this idea of the way we have contextualized the concept of decolonization. And speaking about that, and because I see this urge that we need to relook at the way, the history of how we received and actually accepted law, most of it from Britain, and look at our African traditional society and the justice systems within there. When you easily Google, or even when you listen to the presenters, there's still this term of alternative justice system. Now the term alternative connotes that there's something else which is senior, which is more powerful, and it brings in these questions of the discussions we usually have in post-colonial terms, of the Orient and so on and so forth. So even if we still want to retain the A in AJS, I wish to propose that we take away alternative and have African. So then we just have African justice systems, right? So that even that policy is rewritten and we just have alternative, not alternative, but African justice systems. When we talk about African traditional society, we don't talk about alternative traditional system. We talk about African traditional society. So that then the likes of Walter Benjamin and other post-colonial scholars, if they are here, they will not start beating us. Or even Lumumba's namesake, Patrice, will say, when he was writing to his wife, that the history of what they teach here is just 100th of what is real history, and so on and so forth. Thank you.
Okay, can we first take those reaction? Aaron, son, you might want to start. The mic is...
Yes, I had actually proposed that its functions be reduced, and there were two ways that I had proposed, and one was limiting it to a regulator, and the second way was reducing it to a fund. And the main justification for this was the basis of the act or the establishment of the service was to avail funds, not employment creation, not accreditation. The main purpose was to promote the access to justice through provision of legal aid, which it actually does through paralegals. So with regards to your fears of people losing their jobs, actually when more funds are availed, because reducing the burden in terms of the functions and the work and the administrative staff, it will actually avail more funds, and in that way it is able to engage even more paralegals, and in that way you end up doing more in terms of accessing, in terms of getting the indigent, getting to as many indigent people as possible.
So that when you are seen to be departing from what has now been described as African justice systems, they say this is not the kind of thing we want to fund. We have our idea of what legal aid is, and if you don't conform to our idea of legal aid, then we are taking our funds elsewhere. How then do we ensure that when we define our concept of African justice properly, we are then able to fund them in their informality? I'm thinking of what Egerton University has been doing thus far. You are training chiefs in Marigat, and you therefore want to enable the chiefs as the ones who will be offering this aid. It's possible that your donors now will say, but chiefs, this is an arm of the executive. You are enabling them to perpetuate burdensome cultural practices, yet we know how effective they are in the environment. I would want to hear somebody also enrich those very random thoughts that are coming out of my head.
I think I also, because when you think about legal aid, it is state responsibility. So if the state is funding the judiciary and the judicial process towards access to justice, of course in fulfillment of obligations that they have as a state. So if you advance traditional justice system and then you say, fund these two, again, triangulate that with Professor Mbote's discussion about how many people use the judiciary and therefore how many people, why do we need to keep funding that institution? I think if you were to analyze those three extremes or those four extremes as have been put, you then should be able to come up with a robust discussion to say, yes, we are advancing that, not at the expense of that, but to complement that other system of access to justice. Do you understand where that, and then tie in together with what Professor Abule presented in the morning, do you see how that discussion is rounding up around those areas? Because fact, legal aid funding is a state responsibility. The other people come in to beef it up and to complement it and to make it more vibrant and to give it life and sustainability. But its viability is a government responsibility.
Please allow me to say something about what our colleague Ms. Flora Bidali said in her presentation about the evolution of legal aid in Kenya. I think there's something that has not been said, which ought to be said, which is this. When you look at Section 5(1) and 2 of the Act, Legal Aid Act of 2016, it declares the establishment of the National Legal Aid Service as a body corporate with perpetual succession. Now, this means when you hear the question that Mr. Morris Oduor or Dr. Oduor asked, how do you relate with the Office of the Attorney General? Are you now a parastatal delinked? The answer was, we are a department within the Office of the Attorney General. But that is the situation on the ground. But in the law, it's a body corporate. So there's something, people tell me the law says this, but on the ground, it is totally different. So when Morris asked the question, I wanted to hear a confirmation that Section 5.2 is in force. We didn't hear that. We were told, sorry, we operate as a department in the Attorney General's office. The other issue which is not being said, which should be said, is a lot of things in the National Legal Aid Service are still fledgling. You see, you are just told it's an acting CEO. But from 2016, we are now 4 years. We are still acting. Why can't we have substantive office holders? What is happening there? Then you are told, no, we are waiting for the gazettement of the, I don't know, what is the regulations? Now, we don't see any roadmap or work plan of when things will be firmed up, when accreditation of providers will now be rolled out. There's no work plan. There's no published roadmap. Is it an issue of the board, supposed to have a board, or is an issue of the line ministry, or is a whole, systemic issue? Because as we speak, we have a problem, a standoff. We need 40 judges to help us in the judiciary, but I don't know the system, So things don't seem to be moving. So those are some of the issues I'd like Flora to say. But I also am conscious that Flora works in that office. So I don't know if in her paper she'll have the courage to say, this is the position, this is what the law says, but I'm sorry to say, in the history of the evolution of legal aid, there are things which are going wrong, and see, when you are in the system, sometimes you don't know whether saying what ought to be said is the right thing. There's something called emotional intelligence, so you would rather keep quiet and move on with life.
Yeah, I think the question that had been raised by Dr. Odor, Professor PLO and I can relate, because CLE and KSL are still within OAG, and it's an administrative issue, because if we all derive the funds from one kitty in OAG, so if NLAS has not been receiving money over the last couple of years to set itself up administratively, that will not happen. But I think it's moved further than it was a couple of years ago. So, Professor, I think it's just a matter of time before it completely becomes autonomous. Allow me to allow her to speak, because I haven't had her speak for the last 2 days.
Hi, so I wanted to talk about the issues in respect to traditional dispute resolution mechanisms. And I think that we should be very careful, even as we are proud Africans and we are, proposing that we use these systems a lot more. But I also think that there are situations which do not warrant TDRMs, especially, and I'll refer to Janet Nyaga's paper, where she proposes that we use TDRMs even in child sexual abuse cases. And I'm very adverse to that proposition, just because I think that, for instance, she states that the Gusi community, I hope I'm quoting her right, that in case of defilement, that the TDRMs, propose that you give, that the perpetrator gives 6 months' salary to the child victim. And I'm wondering, is this really commensurate with the crime of defilement? Can we really say 6 months is enough to really compensate this child? And secondly, even as the child is being compensated, who is being compensated? Is it the child or is it the parent? And then secondly, can we really, even when we're thinking about the uniformity of law, and I love that Professor Lumumba has referred to need for harmonization, because we are over 40 tribes in this country. Different tribes and different, even clans, have different methods of how they resolve certain cases. So if we are actually going to state that we should be, using TDRMs, are we really going to be having uniformity in the law? Is it going to be a deterrent? Can we, is this a situation where you can say, okay, this person can pay a number of cows for this, the defilement of this child, and then we say, you know what, you can afford to actually defile this child, and not, and we will totally disregard the Sexual Offences Act, which probably states that you are to serve life, for instance. And then secondly, or thirdly, I'd like us to refer to Section 176 of the Civil Procedure Code, which states, which encourages reconciliation by parties where they mutually, are in agreement that we should, come to some form of conciliation, but it only states that in cases that do not amount to felony. And when we're having TDRMs, and in as much as I love our African culture, but when we're having these different resolutions for cases that amount to murder, that amount to rape, are we really encouraging that we have these perpetrators still running around the streets? Because compensation isn't really the most important thing. The most important thing, according to me, is to have our communities safe from perpetrators. And then also, lastly, I'd refer us to the Cardis Code, which allow for, what I would term as TDRMs within people who profess the Muslim profession, but both parties need to consent to having these TDRMs. And if you look at that act carefully, it talks about matters to do with personal status, for instance, succession, for instance, marriages, and so on. But it doesn't, you cannot resolve a case which amounts to felony in a Cardis court. You'd have to go to, our formal courts or formal courts, quote unquote. And then lastly, Section 6 of the Cardis Codes. If you look at it, it talks about evidence being weighed based on the credibility of the evidence and not the amount of witnesses. And if you look at the mischief behind that act, it actually talks about the reason for that particular provision is the fact that women traditionally amongst a lot of Muslim communities, their evidence was amounted to women would amount to the evidence of one man. So when you're talking about, yeah, exactly. It's very funny. So when you're within a Cardis or when you're within a traditional setup within a Muslim community, you would a woman's evidence or statement was considered as half a statement, and she would need corroboration to, get that evidence to have some basis. So Section 6 of the Cardis Codes is cognizant of that fact, and it removes, some of these cultures from the ambit of our cultures, just to make it so that it is not a very patriarchal system. So even as we are discussing TDRMs, I'd like us to just have some of those, aspects in mind, so that we do not totally lose, ourselves or the need for formal systems, which are, I believe, are equally as important. Thank you.
Comment on Professor Lumumba's, point, and I think he makes a very important point that I can speak to, not just as a member of UNDP, but as a scholar as well. If you look at the what I would call the congenital difficulty in terms of how legal aid, particularly in this country, evolved, one of the things Professor Mbote said yesterday is we need to question how it is that after very many long years, actually decades, of legal aid discourse in this country, it has never taken root. If you look at how, in the context of the 1973, in the 70s, Kituo cha Sheria begins, and then in 1973, and then 1974, ICJ comes up. Again, there's a transnational influence. In the late 70s, 1978, NCCK, LSK come together. In 1983, Public Law Institute is established by Okio Okombaka, who had, went to Harvard and of course came back and, established PLI. FIDA, established in 1985. Again, 1980s and 90s is a time when you have neoliberal reforms, which basically were following state failure, and basically donors were now supporting civil society organizations as a result of state failure. So herein, I think, lies a congenital difficulty in the sense that actually the evolution of legal aid has had these transnational influences, and that's not to say it's a bad thing per se, but I think to the extent that you raise those issues sometimes where the donor interests are there as well. So for instance, at UNDP, we do not take ourselves as donors as such. The EU, the Danish, and those bilaterals are donors, but we take ourselves, as people who are trying to work with the countries we work in and the peoples we work together with. And of course, we are the conduits for those donors, but we try to the extent possible to ensure that there is that latitude. So going back again to this issue, in the 90s, again, you have a variety of NGOs coming up, and I can name them: CLEAN, LRF, there are many, over tens of NGOs that came up in the 90s, and again you see the transnational influence, which points to the issue of the institutional design that I think Aaron, you're speaking to. Institutions which are formed after a history of almost anarchy, where you've had all these different, and I'm not saying anarchy was the situation, but I'm giving an analogy there. You have all these institutions providing legal aid. Of course, a number of them died. Who hears about CLEAN, for instance? Who hears about WOESOC? Who hears about Lepcheria? Who hears about a number of those organizations that were here in the 90s that were actually doing legal aid? So I believe that really what then happens that, of course, in the 2000s, state failure, neoliberal reforms have more or less retreated, and you see things like GAJ laws coming in and NALEP coming in, where now actually NGOs are not really being supported, but it is the state being supported. So to that extent, I think this is one of the reasons why you have this difficulty, whereby these agencies being given all these functions, basically to try and sanitize a situation where you had all this fragmentation, and the way to deal with it is to try and centralize. So I think we also need to look at the political economy, but most importantly, the history of legal aid, and let's invest some time in that question that Professor Kameri Mbote asked yesterday. Why is it that despite all these efforts that we've taken on legal aid, we don't seem to be consolidating? We are still talking the language of reforms. Now we should be talking about the language of transformation and not reforms. Back to you.
Thank you, Dan. So we'll take one comment in here, and then we will, the ones that are connected virtually will also make their comments, and then I will answer her question on why CLE demands that legal education institutions have a legal aid clinic.
All right. Thank you so much. Dr. Kamala, may I know the name of the lady next to you? Oh, Chantel. Thank you so much. Your views were quite thought-provoking. And in my paper that I'll present tomorrow, I'll express my views on the same too. So please, you're invited to also give your view about what I'll present tomorrow. My name is Shemo Ganga. I teach criminal law at Njoro campus, criminology students. My comment today will be based on what Dr. Kamala presented in the morning. And I'll want to say that I could not agree more with what he said about the need for legal representation of victims of post-election violence. Not only to Dr. Kamala or the other legal scholars who are here, pointing out that the tragedy of us Kenyans is the commissions of inquiries that we have that are instituted. And then when the report is received, is always stocked in shelves and forgotten. You know, the commissions we've had since the Moi era, I think now politicians have seen that this is the best way of diverting the attention of the public. There's a crisis in the country, there's even corruption, or there's something very weird. You do one thing, come up with a commission of inquiry, and then give them a mandate of 1 or 2 years, tell them to go slow. And then they go slow. Within 2 years, very slowly, they present the report, and then you just provide a photo in the nation that the report was presented. And then the report, once received, it's not even given to Parliament. It is in the presidential, maybe library. I don't know whether they have that library in the State House. And then it's just there. So, for example, the TGRC report. We're all here legal scholars. And I think had the TGRC report or the Regla been implemented, we would not be having these problems in every election time. And so I'm posing this question to you. Is there a legal way that we can make forcefully the adoption and implementation of these reports by the state? Thank you.
Hello. This is Jackie. Thank you so much, everyone, for the very insightful discussions. I can't remember the name of the person who asked that the name be changed from African Justice System. You then use justice systems that are not necessarily customary. An example of the chiefs, what the chiefs do, I don't really think whether they do that by virtue of a particular customary practice or just by virtue of their office. And I know in other jurisdictions, they have really adopted the neighborhood and community mediation. You have neighbors having issues and resident associations coming in to try and address the dispute. So for me, I think the word alternative is the appropriate word because it should be alternative to the actual judicial system. Anything outside the courts should be considered as such. It's a better name than the rest. What I would want maybe for us to also discuss is on the issue of the service, accrediting institutions offering legal aid service. I would give an example of a number of constitutional commission like NCHR and NGEC, CAJ. They do offer legal aid services. People visit their offices, they give legal advice, and at times do court representation. So would it make sense for a government agency that is offering this service to also pay to NLAS an accreditation fee? And I know there's a decision by Justice Odunga that the judiciary, the Chief Justice pro bono lawyer scheme needs to move to NLAS. So how is that going to work? Because we know the difficulties NLAS has in terms of funding. So when you remove the funding from the Chief Justice under the pro bono lawyer scheme to NLAS, aren't we then going to create bottlenecks, and this would then affect the delivery of legal aid to many people? Thanks.
To complete the session for us so that he gives an opportunity for the presenters whose papers have received some questions to respond to them. Thank you very much for your time.
Yeah, Chair, are you allowing some of us to make an input also, because I was waiting on the other side?
Just make your question
Okay, thanks.
or comment.
Thank you so much. Thank you, Chair. I want to thank all the presenters, really very informative and fascinating discussions. Because of time, I'll just be quick. I noted so much I needed to ask, but I'll just pick out a few of them. The first one would be the very interesting issue raised by Professor PLO and the issue about customary law. I just need to know, why there is no, whether he has an insight of why there is a low uptake of customary law. Is it due to monetary consideration? And whose customary practices can we be looking at when we have 42 tribes? Are we going to codify this into one, or how can we handle that if we are to move in that direction? And of course, the question around how do we deal with the very critical issue that was raised by Professor Ojenda, my alumni here. How are we dealing with issues of quality? Because here in South Africa, we have had situations where people come to legal aid as a stopgap, as a transitional mechanism, while they are looking for a better job. So how do you deal with ensuring that you don't, to use Professor Ojenda's language, unleash incompetence on this very poor, the poor of society, just because they don't have money to afford very good legal representation? And the second last question is that of governance of legal establishments. The issues of governance have come through time and time again. And lastly, how can we market legal clinics so that they can find a central place in the private sector CSR? Because you see, government has got too many priorities. The exchequer is operating on a cliff, and so there's few resources coming through that. So I don't know how many companies, whether there's been any research to understand how many companies set aside a significant amount of their income to legal clinic. Thank you so much, and I'm very much happy to have been participating. Thank you.
Who would like to respond? Yes, Dr. Hamala.
Can I also please say something?
Oh, sorry. Yes, proceed.
Okay. I just want to follow up with what Professor Pilo had said. And there was the issue around the creativity around AJS and the role of the chief. And the fact that if there are institutions that are now being recognized, especially if we want to see how we can use the AJS policy to shape the structure, then it's not just about the chief, but then also asking ourselves, what sort of space do we want to be able to have alternative disputes resolved at community level? I think we can't ignore the fact that at community level, there are always all these different nuances that sometimes is not addressed in court: the cultural, the economic, the social. And it takes, and taking into consideration all those issues when trying to mediate or arbitrate becomes important. The other thing is that we go to these spaces because we say that they are definitely an alternative, because it's faster, because it is cheaper, because it's more culturally sensitive. And if those are the advantages that we're taking to those spaces, then we also have to ask ourselves, if we're talking about mediation and we're talking about arbitration, then we must talk about a resolution that is sustainable. The whole issue around enforcement is something that is very, very weak in these structures that we're talking about. But also the recognition that there's so many. And I also talk about, and I recognize what Jacqueline Ngutia was talking about, that we have different versions, or we have different institutions that provide that. I think we must be able to have harmony. And that harmony means we have got to put in place certain guidelines that is able to ensure that we're talking about fairness, and we're talking about equity, and we're actually talking about sort of quality and fair justice, where we're all at the decision-making tables where we get to speak, and we also recognize that, you know, the gender compositions and the gender complications that come with the issues that are put in, there's need to be able to guide them. So that ultimately, if certain resolutions are made, how do we ensure that they're enforceable? Enforceable in terms of the resolution that's made and ensuring that, for example, women are able to get back to their land. But in the event that she is chased away, do we then go back to the same space? How do we make sure that those resolutions are enforceable so that if the court gets involved, what happens in the event that the same person who was taken to be able to address a matter, who decides to again break whatever law that is now elevated to another level where it stops just becoming a regular case, but it can either become civil or criminal? Because that for me is the disconnect that still remains about what happens in an alternative justice system and then what happens in the judicial. Thank you.
Thank you. So do you have any other questions, or we can now have presenters respond? Yes. Yes, please.
So Section 8.3 of the Legal Education Act allows the council to develop standards and regulations that then allow the council to regulate, to license, regulate, and supervise legal education providers. In the establishment of that criteria, the council also can recommend methodology, content of the curriculum for legal education programs in Kenya. As part of that mandate under 8.3, council has determined that institutions are required to use clinical legal education as a mode of instruction, to establish structures to facilitate that, and that is why we require them to set up moot courts, and to give effect to that, we require them to mount and operate a legal aid clinic. So as a condition of license, all institutions will have a legal aid clinic. And I think conversations that Wambua and I have had over the last 2 years is that the only gap in that is that we have never been able to measure the impact of that regulatory requirement. But do all legal education providers have a legal aid clinic? Yes. Do they run it? Yes. Do they give us report on it? Every year.
Prof, can I? I was one of the presenters. Oh, okay. Even though no question was asked regarding my presentation, there was a comment from Mugure. She said she was not convinced that counties have a role. And I want to link this with this discourse on decolonization that's going on, because we seem to be looking at decolonization as what? Formal versus informal, mainstream versus alternative. But even within the formal institutions of justice, there is a decolonization debate there that we need to have. Why didn't we devolve courts? I mean, historically, the colonialists never gave us a role to run our justice systems. And I mean, that role was not formally recognized in the colonial times. Native courts were established, but they were headed by district officers, if I'm not wrong. So even after independence, I mean, the judiciary has been a highly centralized institution. When we adopted the 2010 Constitution, again, we didn't think counties were responsible enough to run courts, yet we gave them responsibilities to run our health. We devolved our doctors. So I see an issue of decolonization there, that we need to start seeing county governments as responsible enough to run some of the mandates that historically we've thought can only be run from Nairobi or by national entities. And that's why in my paper, the issue of creating concurrency, whenever we see an opportunity, and it's part of the philosophy of interpreting the Constitution in a transformative way, to ensure that the aspirations of recreating our republic, reordering the public order in a manner that conforms with our aspirations, is given effect in how we perceive these institutions. So I still see, yeah, we need to encourage counties to provide legal aid and still have Mary Mugore regulate them as a CLE. Thank you.
Thank you.
You want to respond
to
your question?
Oh,
yes. Proceed.
Yes, thank you. I was going to respond to my colleague, Shem Oganga. But first, he has mentioned something that's very interesting about decolonization of courts. And it reminded me of a discussion I had with the late Zamba Kitonga, who was the chair of the Committee of Experts, about that very issue. When we looked at the draft constitution, his answer to me is, why didn't I go and present those views to him when he was sitting? But the point was, the second liberation was about democratizing parliament, and so that we could not have top-down governance. And people wanted democracy where at least you choose your representatives. Now, there is still one component of maybe the third liberation or something, which will have to do with people taking ownership of the judiciary and participating in judgments. We don't have juries that they had in Western societies, so that people actually take ownership of finding out the facts in any particular matter and deciding who will live in our communities and who doesn't deserve to live among us. And then the judge or the magistrate can simply decide law. Here we blame the court for everything. If they do an election petition decision, the court was wrong or something like that. But if we reach a stage where, and I was asking in the context, why didn't we create county courts, people's courts, so that people could resolve their issues? And it seems to now be being generated in this debate, because it wasn't created formally like that in the Constitution. Now it is informal as mediation or something. And my difficulty is, for example, me as an advocate, I have indemnity. If I do wrong advice, well, at least I'm covered by insurance and the client can get something, sue me for professional negligence. I have a client who, the chief of his area, was trying to give that client advice on succession matters. How, give me the brief and I will tell you how the family should, distribute the estate and so on. The client in the end refused, and it's the chief. He says, I do this for a lot of people. He came back, he's paying my fees and so on. But I can see that competition, that the informal sector will be taking work away from the lawyers. But then I'm saying, but I have gone to the law school, I've read the Succession Act, and I'm indemnified. And so I'm wondering, that quality control debate, yes, it's a real one, because I'm wondering, will the advice be the same? Will the results be the same? They might do it faster, and maybe it's, call it cost effective, maybe I'm quite expensive. I don't know. But again, I'm guaranteeing quality because I have a regulatory body in the LSK and the professional indemnity cover and so on. But just to comment on what you were saying, Bwana Shem Oganga, to speak to the very important issue you've raised about the problems we're having in Kenya because of persistent historical injustices. And we need maybe, in a wider context, it worries me that books like Mau Mau History were written by David Anderson, Carolyn Elkins in 2005. So Mau Mau took place in the 1950s. We didn't have the capacity or facilitation by the state to record our own history. We wanted to forget, or amnesia. Now it's being written by the West. But then the result of that is now you get the House of Commons debating Mau Mau and apologizing. We have the statue in Freedom Corner, which now gives, it's very little, but and then some people were paid compensation, 300,000 shillings, whoever, Martin Day or Martin Lay, I don't know, in London took the cases up. Why I'm saying that is, we are at a point where, yes, there's a Victim Protection Act and a Victim Protection Fund, which would include all these victims, anybody who's a victim in Kenya. If they qualify, you have many communities now. I think the Kalenjin have gone also to England to sue for their land. After World War II, there was people asked the Japanese to, I don't know, apologize. The Jews were given apologies. In Kenya, our historical injustices are simply forgotten. But it behoves scholars first to document and articulate what the right is. The Herero community in Namibia, they have a right to be compensated by Germany. Someone has to say it. And that's the job of the scholars. Once we articulate it, then the policymakers can then, the victim communities can then make their claim and stake it before the courts, and then the awards can be made, and the institutions are starting to be, they exist. So I see us taking that step, and we now need to take that step and actually write our books and get sponsored to write our books. And I would have liked to ask Flora, the legal aid, that legal aid, therefore, does not seem to start at the case itself. There has to be empowerment to articulate the injustices that are there. They seem to have a wider mandate. I don't know how, I'm going to be criticized by Mr. Onyango, who is going to say that I'm giving them too much work. Thank you.
Okay, thank you very much, Dr. Kamala. I want to make a comment, maybe by way of just, a kind of rejoin that some of the presentations that have been done. Professor Tom Ojenda made a case laying a basis for the right to legal aid as a human right. It was a very persuasive exposition, but some of the questions I have or concerns I have need to be addressed. For example, if you say legal aid should be a legal right, so what are the components of that right? And will legal aid be a right that is of immediate implementation, or it's supposed to be of progressive realization? What are the components of that right? And I would like to imagine that when answering that issue, we can isolate aspects of legal aid as a human right which are of immediate implementation. For example, if there are any political, statutory, or other official barriers that prevent people from accessing legal aid, then they should be abolished or removed immediately by way of legislative review to repeal any unjustified barriers to access to legal aid. But I think the editorial team may have to point out that issue. What are the components of that right? Another issue is we have a lot of legislative provisions that promise Section 77, it promises that every child appearing before a court of law, the judge is of the view that the child needs legal aid, then the child shall be granted legal representation. So that is in the law. But on the ground, remember what Justice Matheka said in the morning. The law says the child shall be granted legal representation, and that same representation shall be paid for. Any expenses shall be paid for out of monies provided by Parliament. So the judge was telling us she has not seen that money, but she has had some volunteer lawyers in Nyahururu who have agreed to provide legal aid to children as part of their social responsibility. So the question is, how much even of the current Bill of Rights in the Constitution is for immediate implementation, and how much of this Bill of Rights is possibly of future implementation? Because there are so many promises in the law, but they seem to be futuristic. We have to accept that there is a cost of rights, and not everything promised in the Bill of Rights can be delivered within the existing resource capacities. So maybe some rights are for the future. So we have to then lower our expectations and say, all right, this is a promise, it's a covenant, but it's for a time appointed. As the scripture says in the book of Habakkuk, the vision is for a time appointed. Wait for it. Yes, Prof. Yes, Prof. Yes.
terms of, and Dan Juma also spoke to this particular issue when he talked about the manner in which we have dealt with legal education over the years. As a regulator, one of the things that we tried to do very early on was to introduce what were described them as then as student practice rules. And I hope that something is happening on that score, so that we have students actually practicing under supervision of their lecturers. And if that could be made mandatory, and this should be made a compulsory course for students. We used to do this. I remember at the university in the first year we had this fourth term. You could see it in its embryonic stages, but I think it is now very highly developed. So I would want to hear, and that one of the recommendations that comes out of this to give impetus that student practice rules be instituted. The second thing is something that was said by Ms. Lichuma. There is a problem in this country which we make law, then we look for policy. In other parts of the world, you start from a policy position, then you distill law out of it. I'm very happy that what is now described as alternative, what is it, that name, Evans? Alternative justice has started from a policy position. Then you can distill the law, because in that way, you have a very broad view of what you want to achieve. And I think that is something that also should be done. And then, Kioko, I don't agree with you, but in a very agreeable fashion, because you are suggesting that we should have allowed the counties to create their own courts. Dan Juma has written a very good thesis, his PhD thesis, although it's historical. But having recognized that de jure, we are still a unitary state, we cannot devolve that. The United States of America, whose history sometimes we forget, was created out of independent sovereign states. So they ceded certain things to the federal court system. And it must be understood in that sense. Switzerland, which has oscillated between federalism and confederalism, has also allowed the cantons to do this. What I would have loved you to say, and I'm now saying it on your behalf, is that we should allow the counties to have competence in certain specific areas. And I think that is how I understand things like legal aid. And for quality control, you still want to have the Council of Legal Education doing this. And when we do that, we could actually have these small claims courts. You know what happens with the city council courts, those courts that the city council do with their regulation. And I think those are some of the things where we can distill these issues. And the very last issue is one that is asked about customary law. I think our understanding of customary law is that it's something that is fossilized in time. That these were practices that were undertaken by our ancestors and that they don't evolve. So when you ask somebody whether they want to study customary law, it's as if they are studying historical anthropology and they don't want to be interested in those things. I think it is our duty at the universities to rethink customary law and how we teach it. And the young Chantal has posed very, very important questions. Which one? In which areas? If you say you are going to compensate people, because there are communities, for example, if you rape somebody, then you marry them. So if you are to encourage that kind of thing, you can imagine the number of rapists that would be running around town. So we've got to be very careful in the specific narrow areas in which we encourage some of these practices. And I think that can be informed by the final word that Evans wants to say in response to something about legal aid and something. You are showing me something, verbalize it.
Professor Wabwile, legal aid as a right, I will look at it in the context of Article 49 and 50. Those for me are framing rights, such that the elements under those substantive rights become mandatory they must be given meaning to. They will not be subject to the limitations envisaged under Article 24. So when the Constitution says legal aid shall be, legal aid gives meaning to a broader right, access to justice, fair trial. It becomes an element of a framing right, and therefore is a must.
Okay, Flora sent me a message and she said, I take the questions, she'll respond tomorrow. So anything to do with the National Legal Aid Service, she'll be able to respond tomorrow through a Zoom. And then I have one thing to, Mugure, is it you said that the county government does not have a role to play in legal aid? No, the county government has a huge role to play in legal aid. If you look at Section 98 to 100 of the County Government Act, it introduces issues to do with civic education. Civic education requires empowerment of the citizens about the Bill of Rights, okay? And then at the county government also there's something called the citizen service centers, you know? If you want the citizens really to know their rights at the devolved level, these are structures then that can be used by the legal aid service providers, you know, to provide the services that are needed. And the entry point can only be through the county government. So they have a very critical role to ensure that legal aid is entrenched within the counties. And then also secondly, this one I'm going to say as an authority on domestic violence. You see, under the Act, county governments are under obligation, for instance, to establish shelters. You collaborate with them to create shelters. Now, those are one of the key issues, and especially during COVID when there was a lot of violence within the families and they do not know where to go. If we had shelters that were created by the county government, there would be safe havens for those women or children facing violence. So we should encourage the county government, and I can see someone from the county commissioner's office can take the message that they must still do it. Thank you.
Okay, are you responding to a question? Yes, okay, fine. Please give me.
I just also want to remind us to appreciate why we're here in the first place, and even the emergence of legal aid, as it were. Number one, we must appreciate the fact that there have been a number of problems, especially the justice system failures in this country. Problems with regard to access to justice. So many challenges that have been talked about. And legal aid, in my view, help us to one of the ways through which those issues may be resolved, so that the question of justice can be, the issue of justice or access to justice, as it were, can be addressed. And that's why we are even trying to imagine even the role of these other actors. Like in my paper was, you're not there, but my paper actually, I'm looking at the placing access to justice at the heart of legal education. And that universities that offer legal education should actually make it mandatory. That apart from giving these students the practical of the theories that they learn in class or on how to apply the law, but it also helps in enhancing access to justice within the community. And I was even saying that universities can no longer tell us that their core mandate is teaching and research. That community service must also be one of the core missions for universities. And I look at this in terms of legal aid. Because you cannot talk about, even when we want to talk about other issues to do with rule of law, then if there's no justice, then we cannot talk about rule of law. And of course, even deal with the constitutional promise of human dignity and access to justice. So I think legal aid helps us. And that's why I'm glad Mary has said that they're actually working on that. in order to force universities to actually open. And some people have raised the issue of how is that going to be funded? My view is that this money in this country, the government can actually fund legal aid. And if law schools are not able to provide legal education, then they should not be licensed. It should be a condition, just like I was saying, that even with, like we have with the doctors. Doctors, the way they are trained, see, they train with real people. Lawyers deal with real issues, and therefore we need to train them by teaching by doing. And I think this is central for us even to appreciate some of these issues that we're talking about.
Yes, thank you.
Yeah.
Professor Alphonse Gaskins, and Professor Wabwile will remember this, and those who were at Moi at that time. This was the whole idea, and we had a whole team here at that time from Case Western Reserve University, which I think had the best developed system in the United States at that time, that you actually went into communities and you took out insurance covers for these student practitioners, and you had a person from the faculty who is an attorney. But I think we had a problem with the Law Society. The Law Society took a very negative view of it. I don't know whether this is the time to revisit it, particularly when you say you have 7,000 odd people out there, and we now know that courtesy of the county governments, people are moving down to the devolved units. It would be a very useful thing to have a whole semester where you are in the villages, as it were.
I agree. I think we have 2 or 3 institutions that actually do that, so that they've got both complements of training in their program. They've got judicial attachment and they have community service, except that some have never really been able to articulate the community service towards legal aid, but simply just community service, which means you would end up either in an institution that has got a legal connection to something that's connected to the community. We don't really police that. But I think for us, the takeaway here is to consider whether we can institutionalize the community service that is linked to legal aid, and then link that to the training in law, or find a way of giving academic credit for legal aid, which means that we would require that institutions take it or create a structure in such a way that it's either offered as an unit where you can get credit, or community service that's linked to legal aid that you can then get credit for. I think I get it. Is that what you're all saying? Okay, thanks.
Now let me make 2 more comments. I know tea is ready, and I just don't want to be the enemy of the people. I don't want to be the enemy of the people. It's a book like that by Chinua Achebe. But look, Dr. Maurice Odwor and Ms. Jane Nyaga spoke about traditional and informal justice systems. Now, as I listened to both, I was being tossed from one uncle to the other uncle. I just remember that essay by Professor Makau Wamtua. It's entitled Saviors, Savages, and Victims, a Metaphor of Human Rights. So as I listened to Maurice, I heard him explain some of the horrendous things that some Kenyans have suffered in some parts of Homa Bay County, and I could see images of savages purporting to use customary practices to visit so much injustice on a helpless widow who lost everything and ended up also losing her life. But Jane Nyaga appeared to say that there are some positives we can take from traditional justice systems. So I don't know between the 2 speakers who is depicting the right image of what actually happens on the ground. But I'm persuaded that reading some of the comments of SEDO has identified 10 traditional practices which are harmful to women and girls. And the Committee on the Elimination of All Forms of Discrimination Against Women, when you look at its recent reports, they have identified 10 harmful practices, cultural practices, and I'm persuaded that there's a lot of harmful practices in customary law and customary systems that need to be reconsidered. Finally, I want to comment on what our colleague from UNDP said. It was a very exciting presentation, Mr. Wambua Kituku. Listening to you, it's quite persuasive, because I could see a basis. There were about 5 points laying a basis for the mandate and competence of the county government of Mombasa under its own county legislation, and looking at some provisions, the Constitution, as justifying their provision of legal aid or supporting a legal aid clinic. But Mr. Wambua himself appeared to concede that, yes, there might be a problem. He said that there are 2 problems. One, there are problems of duplication and overlap, because now we have the National Legal Aid Service, which is a national program mandated by an act of parliament and supposed to roll out a national program. So when we reach Mombasa, we find before we reached there, county government was running ahead of us. Will they now fold up and surrender to the National Aid Service, Legal Aid Service, or there will be parallel systems? So it appears there will be duplication of activities and functions between the National Legal Aid Service and the Mombasa County government and the Wajir. So it might probably be wise to tell the other counties to hold on. If they want to do anything, please, can you seek concurrence from the National Legal Aid Service, because this is a national function already. Funds have been allocated to the National Legal Aid Service to roll out a national program. Maybe if they want to support the program, they can support the National Legal Aid Service. But Wambua also told us there might be problems of independence. People might not go there when they have grievances against the sponsor, which is the county government. So again, you can see clearly there are challenges already in the pipeline. So we would encourage you to address some of those issues. Maybe you don't have to abandon your thesis. It's very persuasive, it's courageous, but I think you need just to confront some of those objections and say, yes, these objections are valid, but we think that there may be an alternative interpretation to this. I would like to ask who can now do a vote of thanks so that we can close the session. Yes.
Okay. Professor Michael Obil, did you say An Enemy of the People? Yeah, it's by Henrik Ibsen, the fellow who accuses journalists of misleading people. That's why I have a lot of interest in the book. The compact majority and so on and so forth. Right. I think we need to give ourselves a pat on the shoulder. Today we just cleared it at exactly 6. So that's really commendable. Let's clap for ourselves, please. Asanteni sana. And of course tomorrow we have another very beautiful